Good evening, everybody. I'll call this meeting to order. First up, we'll have a roll call. So Dylan.
Bernal,
Here.
Pahinui,
Here.
Meledra,
Here.
Oshira,
Here.
Smith,
Here.
Durant,
Here.
and Yamanaka. Here. All right, all received, sir.
Thank you very much. Have a full house tonight. Thank you for everyone showing up. First up on the agenda is our public concerns, and I do want to make clear a couple things about the public concerns is these are for items not on our agenda, but on the agenda are specific specific provisions. So if you have any generalized concerns about the direction of the committee or the neighborhood plan, you can offer those. However, I will say if they are specific to certain provisions, especially covering the boards, we will get to those in the future. So it may not be very timely. But with that said, I see Kevin Ly's hand up. So Kevin, please go ahead.
Thank you, Chair. Two general questions or comments. The first would be regarding maybe a potential change to the file naming conventions that we see on the NCO website for this committee and elsewhere. Just wondering what if we have ultimately needed to have two committee meetings in a month, there may need to be an adjustment to the way the files are being named and presented within the current file structure on the new updated NCO website. Secondly, I wonder if the n-plan.org site is still up and running, or at least is cleared for extra domestic access. I've tried to access it on several browsers and through several routers. And although I can get confirmation of a signal that's reaching the Cloudflare system in Singapore, it doesn't appear to be reaching whoever is directly hosting n-plan.org. So I just wanted to confirm if it was still up. Thank you.
I found out today that I can take this second question first. I found out today that it was unfortunately down because I work on my own files and I failed to upload it properly. So it is my error. I had some problems. So it will be back up. I'll do that tonight or tomorrow. So my apologies. That was down at the source. I hosted that myself. As to the first question about the file names, yeah, certainly we're deal with that as it becomes necessary. And I think it'll be clear at that as it becomes necessary. Thank you. Are there any further concerns that anyone wishes to state at this time? Hearing none, we can move on to our approval of committee minutes. Did anyone make a motion? Do I have a second?
Second.
Do we have any proposed amendments? Do you want to offer a proposed amendment?
I just have a question.
Does it pertain to the minutes?
Yes, sir.
Okay. Go ahead.
Listed as, I was listing myself as self, Sarah Kimura, self, but I'm listed.
Oh, maybe you should come up. I'm sorry.
Sorry.
If it's okay, if you want us to make an amendment to the minutes, please come up.
Hello, sorry, I'm straight from the beach, but I just had a question actually, because
I'm sorry, Sarah, can you state?
oh, I'm sorry. My name is Sarah Kimura, and I normally sign it in itself, and I make a point of being very clear that when I testify that, I'm on the Waikiki Neighborhood Board, but I'm testifying as myself. And I just noticed on some of the minutes that I'm actually listed as Sarah with Waikiki Neighborhood Board, so I wasn't sure if that was an issue, or if that's something that needed to be amended, or that was my question.
Yeah.
Yeah, I drafted the minutes myself. I think it's important to note the board members that are present. As you noticed, Kevin Lai, Robert Armstrong, they're also listed the same way. Mr. Carvalho, very mistaken. Did you have a problem with it? Like, are you requesting to not be listed as Waikiki board member?
No, my question was because I guess I'm not reprimanded.
I think this is different than the instruction of if you go to testify, that you say you're testifying on behalf of yourself and not the board.
Okay, I just wanted to make sure that.
I think it notes that you are a board member. It doesn't say that you're representing
Okay,
your board.
perfect. I just
Okay.
want to make sure I'm trying to be.
Okay, So I hear no changes. All those in favor of adopting the minutes as distributed, please say yay.
Yay.
All those opposed say no. Any abstentions? Okay.
One.
Abstentions. One abstention. Wasn't. It's not unanimous, but that's okay. New business. Oh, I kept that. I didn't actually need to put that on the board outreach plan, but I will tell you that we updated the plan, updated the presentation that we went through. And it's on the, I guess, the public drives for all of the boards, and they will have a note mentioned to them about it.
Yeah, the NA's mentioned it, and we also put it on a public drive. There, everyone's email drive. So everyone knows it's there.
And that's if it's not in the mayor's rep report, but we are putting it there so that way if the mayor's representative is there, they'll actually read a bit about it being in there and where you can access it and all that kind of stuff.
That's the the PowerPoint.
Yes, the PowerPoint went through. I did have some additions. I think I mentioned to you, I updated to put a little bit more emphasis on the geographical boundaries issue, just as an example. Other than that, it's basically, and anyone can go view that. Yes, Larry.
In concert with that outreach that you directed me to do, I've been calling other neighborhood chairs, canvassing them on their geographical areas, asking them if there's any changes that need to be made. And I talked to Chair Wood from the INA report. Him and I are going to do a joint resolution.
Okay.
But there are others, but what's restricted me from my outreach is not having the phone numbers for chairs. I got some of them, but I don't have all of them.
Well, I would suggest just maybe getting a little bit, I don't know if there's any confidentiality, you guys can work it out. And yeah, okay, go from there.
No, I was like the other way, too, just blast an email out to everybody that says, hey,
Okay. Just to review on the geographical boundaries issue, we didn't really formally set a standard, but I think the consensus was, and I think it was Commissioner Melendez suggested that we ask for a resolution from the board before we significantly consider anything. And that'll probably be down the line, but just so everybody knows, that was, so it's not just one board member comes in and says, hey, I think we should redraw from here. So, okay, just so we're all clear. Thank you very much. So next up is a report on the application of administrative rules and reorganizational issues. The reason I'm bringing this up again is because we've spent a lot of time on it. Last meeting, I actually went to review the whole thing, and it was kind of incredible. But I did meet personally with Tom Heinrich. Thank you very much, Tom. And we sort of come to the conclusion, and based on feedback we received from the corporate council, that Lloyd was gracious enough to reach out and get some clarification. I think based on those, it is pretty clear that these are administrative rule issues or laws, so we will have to follow the administrative guidelines. However, with that said, we had talked about combining the plan into sort of one plan and not have that bifurcation that was required before, where you have the commission, you have the boards. That does not seem to maybe apply. We're not really sure, but at this point, and I hope that what I felt from the committee is that we're making the determination that we're just going to go forward with how we've adopted reorganization, and this will be one plan, and we'll combine a lot of things. And if it comes back later down the line that we can't do it, then so be it. We make adjustments at that point. So I want to get everyone's heads up. So with that in mind, I don't know if anyone had any comments about that, if any of the committee members. So with that in mind, I actually left all the provisions on the committee because there will be some additional comments in light of the administrative rules and such. So that's why everything, even though we rehashed everything, I think we can move pretty quickly through at least 101 through 105. So we can start. Just as an administrative note, we talked about it at the last meeting. We didn't really adhere to it because I said I didn't announce it before, but at the last meeting, we asked for public comment before on each of our provisions, and then the committee will make the deliberations. If we have a question of the public, we may take that time, but the time for public comment is before we reach or before the committee starts the discussion of each particular provision. So with that said, we can start out and this is under the reorganized numbering scheme. Section 3-1-101, and we have gone through the first 5 provisions, but we can do it again. Is there a member of the public that wishes to say anything regarding this specific provision? It's just a short title. Hearing none? Okay, Tom, go ahead. Yes.
Thank you, Chair. Tom Heinrich, speaking in my individual capacity. I appreciate having all of these back on the agenda just to kind of start the ball rolling all over again. And in light of the comments that you just made, I wanted to emphasize a couple of things here. So I'll go just a little bit beyond 3-1-101. But I appreciate, as you did, having the original site right there because it makes the back and forth that much easier. First, there is that distinction between 211-101 and 212-101, separating out the rules and procedures of the commission versus the neighborhood plan. Okay, so again, that's that distinction. I would offer this comment as an aside, and that is one of the things, Chair, you and I talked about outside of this meeting, was a different alternative, and that was maybe other than specific amendments, maybe you don't do the reorganization, but in fact, we provide from the Neighborhood Commission office a summary of the plan or whatever. You want to talk more about this? Now look at the specific rule, but something that would be much more of a shortened introduction or whatever. Okay, so that's something that we've talked about, and I said I do an outline in a few ways on that because still the rules in and of themselves don't provide those additional side comments that are not intended to be rules, but are intended to be contextual. Okay. That's all I have to say on the first one. I do have something on the next one. I'll come back to that.
Thank you. Just to address your comments. Now, we talked about this where the old section under the current rules where it's, was it 2-11, which is the commission. And then you have 2-12 and everything that follows. Which are neighborhood.
Yes.
This committee has decided not to follow that convention. And now you may not agree and you may say, it's wrong, we're going to be overturned later on, but we've decided not to follow that. And so that's what I hope I made clear to everyone.
Yeah, and in the context of the committee and how you're reviewing this and all the rest of that, perfectly fine.
Okay.
I think for that clarity, it is a matter that as you keep the original sites on the agenda and everything else, it just makes it that much easier. Okay.
Thank
So
you.
it's all an exercise in how you make your presentation.
Oh, okay. Oh, if
Yeah.
you're talking about the review process. Okay.
Yeah.
Thank you very much. We
Yeah.
appreciate your insights. With that said, are there any comments about this particular section, the short title?
I got Kevin Lamar.
Oh, okay. Well, maybe I missed you. Go ahead, Kevin. This is just 3-1-101.
Thank you, Chair. Just a global question then, and I believe that Mr. Heinrich may have just touched on it regarding the citations. The minutes from the just adopted meeting from September, I recall that we discussed the retaining of the references for each of the sections and subsections. Is that something that's been clarified here? We will retain those in the final product. That was my question to apply to all the sections. Thank you.
That I don't, well, when you say the final product, I don't know. Now, when we do that, Ramsmeyer, I think is how it's called, right? So when we have that available to the public, all those references will need to be in there. But I don't know if in the final version, once we get the final version, I think it'll just be all, yeah, they'll fall out. Does that make sense? But it will be for the public review.
Okay, thank you, Chair. I guess I thought I recalled from discussion during last month's meeting that it was felt that they would be important to have, but again, at the discretion of the committee.
Well, just to be clear, they will be in there during the review process, but they really won't be necessary after this because it'll be, the plan will be almost a new plan or revised or that sort of thing, amended. So it won't be necessary, I don't think. And if you think it is, then, you can make that observation when we sort of get towards the end. Okay?
Thank you, Chair. It just seemed that there were references to other parts of the government documents not within the former neighborhood plan itself. But again, I'll reserve comment for later. Thank you.
Well, those will likely stay, because those have to be, if you're talking about references to legislative, like, the charter or HRS, then yeah, those will probably stay.
Yes, sir. Thank you.
Thank you. Commissioner Melendez.
Question. Do we want to keep those somewhere in the document for contextual reference legally? Because there's really a lot of thought that went into those. When you talk about a document going from one to another, a lot of times legally we make traceability and accountability. If a question comes up later, if it doesn't, we're fine, but who knows what's going to come up later. I've gone through meeting minutes and notes that were like 3 years old, 4 years old, legal, that were being adjudicated. And so there's something like this, there's so much rich information there. I'm wondering if we should maybe make it footnotes at the bottom of the page, or some way like this, some way you write a book. Giving a traceability back to how this originated in the beginning. Then you don't have to go back through it again. That's your consideration.
Maybe you could have a legislative history type of document, I suppose.
It's not necessary. You keep the Ramsey version and then you'll have that. You'll have all the drugs and stuff. So I would not ever recommend getting rid of the Ramsey version, but that's what you use. You just use that as you're going back. In a final version, you don't want all of that other stuff except for the HRS and the citation.
That's what I'm saying, just a citation, not the other information.
Like you see
Oh,
here,
yeah.
yeah, you need to keep that.
Yes.
But I always recommend keeping the Ramsey, but that's a whole separate issue.
So just to be clear, so when we take this public hearing, the document that is going to be presented is a Ramsey version of what we're doing now. Which means that if it is in the current neighborhood plan, like this is 212-101 and the new one is 3101. This will be the base document, right? The old neighborhood plan, and this you will stick in the Ramsey format to show what the changes is. And if you have no change to the substance, it will just be the change to the citation, the number,
Yes.
the provision. So that'll be the whole document. It'll be the old plan with the new citations. And if there are any substantive changes, that's what will be shown at Ramsey.
It'll be like outlined, I guess, cross.
Who do that?
Well, my,
Oh, the reason I ask is because usually when you're doing this kind of review, you work with the old document and then you start with the Ramsey format rather than like the whole new document that you presented. So I'm gonna have to convert what we're looking at, the new citations back into the old.
Yeah.
yeah, I think it's not a small job,
No.
but it just
Sure.
depends on how you attack the problem, so to speak. I
Mhm.
mean, and I think just to make it simple, we do the substantive work and then, yeah, it's going to be some work.
However you do, it's gonna be complicated.
Yeah,
But
so I
Richard's
think
right.
you do all that.
It's
stuff at the end. No, I agree.
I've
And-
done it. It's not fun.
But I mean, you're gonna, and then the citations are, I mean, the
Yeah.
ordering is huge in terms of the,
But-
so.
That's that will become the history of what we did.
Yeah.
Yeah, so I just think what we do is worthwhile, then, we just.
See, because
do it.
when you, at the end of this process, all the changes we made, take it to public hearing, there may be folks that never saw
Right.
the new version that was adopted in terms of what we're looking at now. So all they have is the old neighborhood plan, so they're gonna look at that,
Right.
see what's being amended. So that's why if you have the Ramsey format, then that'll tell them exactly what's being
Exactly.
changed. right?
Yeah.
Yeah.
Okay, so that
And
it makes sense, but it's still a lot.
Yeah, and quite honestly, off the top of my head, I really haven't looked into how the reorganization that works because a lot of times I've seen it where it's all.
It's gonna be messy.
But I just figure that's kind of something, just like all the formatting issues, we worry about that at the end and because that's just a lot of work.
Perhaps the format in one sentence, right?
Yeah.
You know, all the material is underlined, all the material is to be
Deleted,
deleted.
right, correct.
Yeah, it's
Practical, basically.
Yeah.
You have other versions of that, but basically that's, crack it out, let's take it out. change it, and then you stick it, use stuff, just leave them like it. It's like reading a book.
I said I wasn't gonna call it public, but since we talked about this type of stuff, I know Tom is sort of expert, so please sort of share what you have.
Okay, thanks. That was not in there for me. Okay. Tom Heiner, just real quick. I read through, yesterday and today, certain portions of the latest edition of Hawaii Administrative Rules Drafting Manual, and something particularly caught my eye. While we are very used to the Ramsayer format and all the rest of that, dealing with the administrative rules now in terms of here's what we propose to do, here's what it's going to look like. In fact, there were major changes made with the 2017 edition such that the major focus now is not so much to try to show each and every change in that for what would be the proposed final document, but rather trying to simplify by showing the amendment, or the way the process works is proposing the amendment, which has the changes, and then adopting a compilation. In other words, instead of, I've got 18 particular amendments to make, and the old way was then you make those 18 amendments, and then staff has got to come back and go, okay, where does this fit in, or whatever. It's a lot easier now in terms of, it's still heavy lifting at the beginning, but it's making the amendments and then showing the compilation so that, especially for public review and everything to show where we would end up is simpler. Okay, so there are some important changes here that have tried to make that process a little bit more efficient while still being able to take a look at the Ramsar part. Okay, so we end up in an easier place.
Good.
Thanks.
So it'll happen one way or another, I suppose, but for right now, I would say let's focus on the substantive and I mean, those are big issues, those are big issues, but at some point we just have to put in some effort to get it done. So we ready to move on to our next provision? And that is 3-1-102. And I will let you know that currently, because we had that bifurcation, one being the rule set, which is 2-11 for commission, 2-12 for and everything that beyond for the boards. We have two sets of definitions. They are 2-11-102 and under the current plan, and 2-12-102. So what I would suggest, and the reason I want to revisit this will not be what we're reviewing here. We're not taking the plan from the beginning. This is because we're trying to do the so-called easier part first. And so the definition, if we follow that model where we have one set, I would suggest that we keep the definition section, and the new one will be 1-1-102. And anything from this part of the definitions that we feel like we need to keep, when we go back and we revise that one section of 1-1-102, we can then insert them in that specific set of definitions. I know that's a mouthful. Is everybody clear on that?
No, but that's okay.
So in other words, we're going from two sets of definitions.
Right, to one. Yeah, thank
And
you.
so the latter, the one that we're dealing with now, we did delete it the last meeting. I would suggest that we keep it deleted because it'll all go back into other set,
Right.
which will be first.
I get it.
Okay. I know it's maybe I didn't say it.
I'm sorry, I missed the last couple of meetings, but really quickly, will there be a moment where we can add to the definition section?
Well, I think what I would suggest is when we get to, even though we're doing it a little backwards,
Yeah.
when we get to 1-102, which.
That's the time. to do
That's
it.
the time.
Okay, thank you.
And that's the time to go back and maybe check this provision that we're gonna
Thank
delete
you,
and say, yeah. And,
Okay.
and, okay, so is, and I didn't ask for the public input at first, so Kevin, please go ahead.
Thank you, Chair. My comment may be moot given what was just described, but I just wanted to see if, for example, the commission looks at the current definition of, let's say, delegate. And within its definition, there are references to section 3-1-318, 2-2-125. In other definitions, there is a clear reference to what document those types of enumerators are referring. And in this case, it might be something within Title II, I'm not sure, but I just hope that we could make sure it's uniformly clear for any of these references that a naive reader would be able to look at it and readily be able to find what its source is or to what it is referring. So I just hope that we could just put a pin in trying to refine that down the road at the appropriate time for all the definitions, which include those types of references. Thank you.
Thank you. Actually, if you wouldn't mind emailing me that, so I can make clear exactly what you're referring to. And yeah, when we get back to the 1-102, yeah, we definitely want to clean that up if necessary. So thank you. Are there any last comments or anyone wish to make a comment? All right, Tom, to the heads. Following what rules. Okay.
Thank you. Tom Heidner.
Yeah, Tom, just stay.
No, I need the exercise.
Now you're coming back.
I will hold off on certain suggestions for amendment, if you will, because we're doing that later. But I wanted to note particularly, we had part of this discussion at the last committee meeting. But bottom line is being able to go back and forth and absolutely compare. I'll use the old numbers, 211-102 and 212-102. There's absolutely no duplication in those lists. There's no better reason for separating the lists. There's one addition that we might want to do for clarity about district, because there's a definition for sub-district. So there's some interesting additions. I'll be interested in what Kathy has to possibly add too. The main distinction had to do in the first sentence, and that was in this subtitle, which is the entirety of the rules for the commission and the neighborhood plan. They draw in those distinctions. And then otherwise, in 212-102, there's the addition of the word specifically. In other words, unless the context otherwise specifically requires. I don't know why Corporation Council added that one compared to the draft that from all the rest of our community process, et cetera, we offered. Also, there is a difficulty in timing, if you will, of language. In 211-102, this is the first list, the definition for board refers to this plan. Well, you haven't introduced the plan, you don't know it exists yet. So there's a little bit of refinement that would be there. But the big picture is, I think as originally you started with your original comments when we started this whole thing, to consolidate the definition section into one and one place only, and even to double check the rest of all of these chapters to see if there's anything else that should go in there as appropriate, then that's the way to go. Because right now there's no good purpose except, oh, this is the rules of the plan, excuse me, of the commission, this is everything else for the plan, and yet the rules apply to the entire document. Okay, so definitely consolidation.
Yeah, I think even if we end up putting everything from this section into the other, it's still a matter of putting in all of
It's just
it,
a word at the front. That's okay. Yeah.
rather than having two separate definition sections.
Thank
So, we will retain this as deleted unless there's any objection from the park committee. Okay, with that said, we can move on then to 3-1-1. sorry. And we did make, let me find my notes about changes. Goodness. All right. I do believe oh, yes. I would say, there was a question about subsection C, and that is price fixed by law. So I went to, look that up and I found that, there is a copy fee and I think in, HRS 92. And then, but there's also a possible compilation or other charges like having to research. That fee can also be on there too, and it's not a fixed cost. So if we wanted to kind of define more about price fixed, what that means, it gets more complicated. Now,
I know, but I was just, thank you for bringing that up because I deal with this all the time at work. 92F UPA, Uniform Information Practice Act. And I think it's important to reference that here because that's what most people will look at. And I think that's what most offices will look at in terms of costs. So I think just referencing, just saying HRS 92F or whatever that subsection is, just keep it simple, but that's what we would go by if somebody called us up and wanted a copy of something.
okay, well, we can add that if there's no objection. And I actually do have both of those sites somewhere. Since I got all this
I can
paper.
find it, I'll send you I
Oh.
deal with it every single day.
Okay. Well, that's all right. I mean, actually, I looked it up and got both of those things, but we can check
Yeah.
notes and make sure that we're
Yeah,
on the
that's a
same
good,
page,
good.
Yeah.
just in case, because if you deal with them, then I might be wrong with some stuff, so. Okay, anyway, well, then that was the only change that.
I have another one, I'm sorry.
No,
Sorry.
no, sorry.
The other thing I've noticed in here, because we have to deal with this when doing agenda, is we don't have anything in here for people who have a disability.
Right.
So I think we do need to reference that, we provide accommodation or whatever that language is. You can call up Denise in the office and the city office and get that. I think it's really important to have that there. We have to put it on all our agenda.
Because right now,
That's right.
there's 3 options.
Yeah.
Fax, email,
Right,
so we can option 4.
yeah. But just say, we can make what they call accommodations are needed. Please call us at this number. We don't have to get into the details. But we should make it clear that we make it available for ADA.
So, just really quickly, just for clarification, I don't disagree with what you're saying. I think it's a good idea. I'm just wondering, in terms of a section sort of perspective, that's falling under to obtain information.
Yeah.
Because if somebody doesn't know or they want the agenda, but they're blind or can't hear,
Okay.
that's what I'm thinking. It's just like exactly what we put on all of our agenda.
Okay, because I think, because when you bring that up, what I was thinking was, because right now, one thing that's actually missing out of this plan to me would almost be something like, what does an agenda look like? And are there certain requirements that need to be on an agenda? And that could be one of those things, like, yes, to have this language on it. I guess my only concern, like I said, not that I disagree with you, but since I've been working in this office, that language for the ADA compliance and requesting a translator has probably changed 3 or 4 times.
Oh, yeah, easy.
So what I'm concerned about is, it's like coming in with good intent, but if the language.
That's why I say don't put the language in there, just say, we provide accommodations for those with disabilities, please call our office at, and that's
Okay.
all you have to
Okay,
do.
yeah.
I agree with you, Dylan. Yeah, you don't want to, because otherwise they'll be changing it every couple of years. But we should acknowledge the fact that sometimes people have a disability.
Our regional accommodation for the CHRS.
Right. The other thing too, that just popped in my head is what about people that don't speak English? I'm not trying to complicate things, it's just that these are the things that you get sued over. By not making these things available.
Do you want to maybe yes or which?
Yeah, thank you. Tom Heinrich. Just a couple of things. I very much appreciate Kathleen's comments there. This is something that I think you cover in a sentence or two. You're stating a policy in the plan, but the rest of your detail, in fact, you leave for what I'll call the operations manual, right? The internal manual, which is available to the public to review if they desire. But in that regard, all the rest of the operations is what you keep updated, but you set the policy here. And when we did this now 16 years ago, whatever, in fact, that was not so much an item of discussion in the way that it is today. And adding another subsection to this section, I think is wholly appropriate in that way. So the other thing I just wanted to emphasize is there are some things that definitely are far better in the operations manual as compared to having to make any rule amendments and having to go through the administrative rulemaking process. But by at least touching the tip of the pyramid on the policy, you've got it covered.
I agree.
One other quick comment is there are several places in here that I think we need to more appropriately reference either the NCO website, meaning the agency's website or whatever. So there's some wordsmithing to do there. Even in terms of getting copies of the plan or whatever, since most of the things that we're talking about now, you actually post on the website or one way make available on Google Docs or whatever. So there's some things there. Again, state policy, but the details going down. Thank you.
So do we create like a section E and say the commission will provide? Oh, I'm sorry.
F.
Okay, yeah, F, and the commission provides accommodations for individuals with disabilities. Please contact, or not please, just contact the commission.
I'd say disabilities and those that speak are non-English speaking. And then please contact,
I'm sorry, what was that?
or non-English speakers,
Non-English speakers.
And,
non-English speakers.
Yeah.
Thank you.
okay, and that will be provision F.
In section 3-1-1.
Yeah, so. I'm sorry. Okay, so anything further on 3-1-1? I think I'm just gonna call it 1 and 3. I mean, it's, we're same thing, so.
Yeah.
Yes, Dylan.
Just the one thing that was approved at the last meeting was deleting facts.
Thank you. I meant to say that. So in section A, we deleted where it says at the very last part of it, by letter, fax, or email, we deleted fax. Are there any issues with that? Okay. Sorry, I didn't.
Oh, so there's
What
two
is-
options right now. Then
Yes, we just said letter or
email.
What if someone still using the fax?
well, I don't know. I mean, the last time we just had
Don't.
fax.
You
Okay.
get the receipt. They don't have a fax receipt. Yeah, but lawyers, if you send communicate to a lawyer, an email is not actually a fax is. So they're gonna ask for the fax. I don't know if it's worth it to take it out.
Oh, I don't know that I agree with that, Steve. We deal with lawyers all the time and we send them stuff to deal with via email.
For the court, because it's date and timestamp.
Now, I do know that DOH and other places still use fax, but I think in this case, it's
Yeah, we do
okay.
too.
I think we can delete it.
Yeah, I mean, I
If somebody called up and said, can I use a fax? I'm sure they'll run around and find the old machine and plug it in.
I don't think anyone in our office knows how to use it.
yeah, the kids have always.
On all of our copy machines, they'll have a built-in fax.
Yeah.
Because we have 149,000 members.
Yeah.
So
This is provision.
I don't even think they call it a fax though, even though it's on the copy machine. We do too, that you can email stuff to people. It's via email though these days.
but it also does, it's actually a fax card.
Yeah, ours doesn't have it anymore.
Okay, so I'm sorry, I hear the consensus seems to be to eliminate,
Yeah.
to retain the elimination of
Yeah.
facts.
Facts.
Yeah, and like Kathleen suggested, I'm sure some calls they'll have a workaround, but I don't, on a daily basis, it doesn't sound like it's
We'll do the best we can to accommodate what is possible, but I just don't want to set us up to promise.
Yeah, that's.
You can't even do it anymore, yeah, exactly.
Copy machines don't have a fax clerk.
Well, I mean, the fact that
Receive or send, or it's not-
the only attorneys that they need to really worry about with faxes is corporate counsel, and you already have because the other attorneys that are gonna transmit things will be public documents.
Or just members, some people are not computer savvy.
Okay, well, please, can you say, if they can't take faxes now. So, sorry, I have to move on. So going to 104.
Chair.
What? Kevin, go ahead.
Thank you, Chair. If you still are taking comments on 103, I'm reviewing the testimony I submitted to the September meeting. I hope it was propagated or circulated for the October meeting. But if I could ask about in 103, I believe it may be current section E regarding the mailing lists. I wonder if this is an appropriate place to try to clarify an issue that arose now almost 2 years ago when the Neighborhood Commission, at least at that time, would distribute a agenda and meeting minutes pair to the city office of the county clerk, which would then distribute those documents. I'm not quite sure how the process goes now, if that's changed significantly, but because at one point there was a misdelivery or certain members who had signed up for the mailing list did not receive those particular documents, it led to some questions about the validity of the holding of a meeting. So I'm wondering if that process can be clarified here now in this section or elsewhere.
Did you want to address that?
I think the issue is external to us. Our general process is we receive the agenda from the chair and after, theoretically, they review the minutes as well, then with the secretary. And then after that, we print it out, physical, and those all get ran through a mail machine and then delivered to the addresses that we have. And then on the digital side, we send a copy to the city clerk's office, and then it also gets posted on our website. So if someone's not receiving physical, like if they didn't get a letter from us, maybe they usually do, but there's one that's missed. I mean, we can't really discuss how the postal service delivers, if there's a missed delivery or, I don't know.
Did that answer your question, Kevin?
I just don't know how you could legislate that into a plan on how we could do anything else other than that.
Yeah, thank you, Chair. I think that's how things kind of broke down when we spoke with OIP about this about 2 years ago. But if there had been any change in the process, if Office of the City Clerk was still involved, which it sounds as if from Mr. Witzel that the mailings are done directly by or through the Neighborhood Commission office now. And I think that's part of why we've seen changes in the format of the mailings by email that we receive about the meeting agenda and minutes that don't or do no longer appear to include PDF versions of the files and are requiring folks to click through to the Neighborhood Commission office website to find those hardened PDF versions of the amendments of the agenda rather and the meeting minutes. So I think that's where it stands. But thank you.
I'm not really sure because I've been involved with this office for 7-ish years. It's always been done by the office.
Okay, so I assume that we're all done with 103. So next we'll move on to 104. We did have a correction for subsection D, which forgot to write that out. I have it on my notes at home. But do you have that language? It was like the commission, well, essentially what it was, the commission, subsection D, the commission will state one of the following reasons for refusing to issue a declaratory judgment. Hey, Kevin, can you remind me what that language was for subsection D?
Yes, thank you, Chair. I'm going to try to post into the chat, but it was adding a clause. The commission may so refuse and cite the specific reason for such where, and then the super subsections. I'll type it into the chat.
Well, that's okay. I have it. I just wanted to make committee members aware of that change. So it's essentially cite a reason, one of the 4 reasons for refusing to issue a declaratory judgment. Under subsection, did anyone have any questions about that? Okay, so under subsection E, let's see, I'm sorry, subsection F, where it says the petition shall be promptly informed. No, I think that was made moot by the subsection D response. Never mind, that was not updated. So I don't think there were any further updates for that section. So are there any, Tom, if you want to add something?
Well, one question. Because I don't recall exactly where this may have come from back in the day. Section 104, subsection B, that first line, the petition shall be submitted in duplicate. I don't know why we need duplicate.
That's a good, I missed that.
So
And so that's my specific comment there. But if I can sidestep for just a sec, I had this conversation with Lloyd before the meeting started. But want to note from earlier discussion in this meeting that one of the things that really got squeezed out of the sponge, unfortunately, by Corporation Council years ago was when you look at the last notes at the end of the sections, the authority and the implementing. Most of the notations there only refer to revised charter of Honolulu and a couple of sections that's just simply say the commission can make its rules or needs to make a plan. And so some of the references that you've already made to HRS chapter 92F or other things like that, that information was provided and that really needs to go back in to the notations here. So some things like that don't necessarily go into the text of the section, but all your references where you get a lot of your detail, which got taken out, really contrary to the drafting rules, should go there. And then the last thing is I also offered at my peril to Lloyd to take a look for other typos, some of the effective dates and stuff, or maybe the last changes where dates got flipped. It should be in chronological order, but other things like that. If Lloyd is willing, I'd be happy to put in some, as I call it, proposal time to check that.
That would be fantastic, especially if you could give me the sites for the.
That's what I'm going to look back. From
Thank you
from the
so
original
much.
stuff.
Just,
Like Kathy said, we don't give up the Ramsauer earlier drafts.
thank you.
Okay, thank you.
So, just so everyone's clear, so when we have under subsection B to say the petition shall be submitted in duplicate, is everybody okay with deleting the duplicate language?
yes.
Okay, so we'll consider that. Next, let's call this. Okay, so is there anything further in section 10? Oh, Kevin. I guess it's.
Chair, thank you. What may be subsection F, upon the disposition of petition, the petitioner shall be promptly informed. I think one of the comments I suggested last month was, is there any clarity needed for promptly? Because it really leaves open the possibility for delays, which could, in a certain set of combinations of circumstances, allow the commission to just sit on an inquiry or response without any fear of consequence by just delaying. Didn't know if that's something that should be addressed. And similar, there are other kind of loose language terms like this throughout the document, which might be tightened up, especially when we get down to the complaint process. Thank you.
Thank you. I will remind, I will let the committee members who weren't here at the last meeting that we did talk through this, and sort of the idea was promptly is vague enough that it depends on a reasonable person. It does imply that the office or the commission should act within some reasonable mind or some reasonable time frame, but it does not require, which can get a little sticky. So I think the consensus at the time was to sort of leave that alone. Does anyone want to offer anything about changing that
I have a
language?
comment.
Yes, go ahead.
Are we doing that with state contracts, something like that? we just say petitioner shall be contacted per, and then somewhere else in the document, you define the word promptly as or the normal contact time for such and such. You have it somewhere else in the document. And then when you shall be contacted for such and such. We don't have that.
Well,
You would add that.
and I thought that, I think the thought was to leave it vague. You know, and yeah, if we set a time, then that would sort of eliminate, I don't know, Boyd, you're here, what are your thoughts?
I agree with you. I think, leaving it vague because you're trying to make a rule about something where we don't know what situation is at that time. So there is some discretion in many areas that the commission can have. So I don't see it, and I agree with the previous decision, but it's making that sense.
There's benefit to both.
Okay.
On one side, you get complaints, but they don't get it. If you have at least identified somewhere in the document, and then you know what you're shooting for, and that's just turned that into SOP. Within a week, 2 weeks, whatever that might be. But if it goes up for months, then you get complaints,
Well,
and then it gets legal.
people would complain, but here, at least, if you say promptly, then it depends on how you define promptly.
Yes,
So
you
you can't say someone's, has a legal complaint, then they're gonna take it to court to,
Unless you conflict with something else.
yeah.
In the state side, we have dates, like 5 days to put a single one.
Well, I mean, we could do that, but like I said, we left it vague because we want to leave it vague. So it just depends on what the
I
committee.
think it's good not to be locked into a real, I think it's, as Tom said, operational, that's something that could go into the operational manual that he's talking about, versus being real specific. I don't know that we want to be overly specific other than where it's like prompt.
I think we've decided, but do you have anything you really want to add?
Yeah,
Okay,
just want to point out, this is one of those rare situations. The site to interest where we took this from is there. That's what does get real helpful to make sure that we're authorizing and implementing the sites are there. So section 91-1 interest.
91 dash what?
91-8.
Oh, that 8, okay. That way okay. But in any event, okay, so I think the consensus on the we can vote, but I think the consensus is to leave it as it is. Sorry. Are there any other, Kevin, I see your hand up, please go ahead.
Chair, thank you. Just to follow up on the last point, just from a personal perspective, I know that I've submitted requests for clarifications and whatnot through the neighborhood plan current version. And it's been months, if not years, since receiving acknowledgement or recognition or responses from such. That's why I'm, personally advocating for clarification on these vague timelines, but the comments of the committee are noted. Thank you.
Thank you. Well, we say promptly, if the commission's failing to do that, then it's failing to do it. And, but, sorry. Moving on, are there any last comments on section 104? Okay, hearing none, we'll move on to 105, which is severability. At the last committee meeting, we did actually ask this, but I will let you know that just like with definitions, there are 2 severability clauses, and there is one that, and I have it in here as the site. I'm sorry, but yeah, so we have this is uncurrent, 2-11 and 2-12, and they're both, well, one's 105 and one's 103. But in other words, there are 2 severability sections. The other severability section will come at the beginning, so I would suggest that we just keep this deleted because there will be one for the whole document, so it will be in,
Yeah.
or at least,
Contractually.
yeah, so yeah, this one will be deleted, but there will be one. Okay, so now we're venturing into new territory. And that is, we're taking up section 106. Hopefully, I'm trying to find Kevin's comments. Kevin, go ahead, please.
Chair, thank you. Regarding subsection B of 106, I just wonder if there are any conditions other than an election process which could be impacted by weather catastrophes. Do we need broader language or something more general that could suggest that if there are these, force majeure things that happen, that they will apply to things other than election process? Thank you.
I did know that, yeah, you had stated like if there were hearings or something, I would assume that those would just be canceled. So these are, when you talk about filings, it's probably harder to say you cancel the date of a filing. So that's probably why you have filings, but you don't have any specific events such as hearings. Does that make sense? That is probably not necessary.
I'll think on that. Thank you.
Okay, that's all I can ask for. Are there any observations or input by the committee members? So does everybody gather what the comment by Kevin was just to include, other scenarios. So, okay, is everybody clear? Hearing none. Are we okay with 106 then?
Yes.
Okay, so we'll move on to 107. Are there any comments? Okay, well then, the executives, Tom, go ahead, please.
Just real quick, this short little section was added from a lot of the time that we put into overhauling the plan for the simple reason that there were a lot of questions as to what's the role of the commission? And of course, the commission has no role in the hire or fire of the executive secretary, et cetera. And most people talk about, well, the executive secretary reports to the mayor. Technically, that's correct, but it is through the managing director. So just with this right here, we wanted to be clear as to that portion of what is the chain of command, because it then bolsters the one or two other statements in here having to do with even if the commission wants to pose questions or pass on questions to corporation counsel, it is done through the executive secretary, et cetera.
So well, that'll be the next.
Yeah, this is one of the real key additions that we did back in 2008 on that.
So unless, since it covers you, Lloyd, you don't have any comments, do you?
I thought he said it perfect.
He did.
Okay. So,
Circled through.
Larry, go ahead.
Yeah, I got one detail. I think it needs to be specific. There are many commissions underneath the mayor. It should be where it says, the executive secretary reports to the managing director, serves as administrator for the commission and the neighborhood commission office. Because there are many.
Yes.
And the NCO.
Yeah.
You have to reference this in the plan. Because you change this thing, but change all, if there are others.
I think they put.
Well, we're going for specifics in here.
There you go.
No, no, I think they definition, like commission means commission office. So
Yeah.
You can do
Oh.
So what was that?
Well,
I
could you
think-
say
think
that
they
in the
put-
definitions where you say commission here it means neighborhood commission?
Neighborhood.
Is that in there already?
Put that in
Yeah,
the
like
definition.
commission office in there.
Yeah.
Commission. So
Sounds good.
reading the land use.
Okay, so,
Retract that.
so with that noted, so we're okay, everybody's okay on 107.
If even if I try and expand my power, nobody's gonna pay attention to me.
Oh, pay attention to you.
So Kevin, is this about 107?
Yes, Chair, thank you. I was just wondering, and maybe Mr. Heinrich is the person who can answer this question directly. Is it, or which of the references in the citations there point towards that connection between the executive secretary and the managing director? Is it within Title II? Is it 211-107 or one of the revised charter references? Again, that'd be helpful.
That's a good point. That one actually is not cited in terms of everybody reports to the managing director. I don't have my chart.
I've got the applicable part of the charter, Tom, if you look at it.
Hold on just a second. You can, it's just the section for September
Hold on,
14th.
there's something from chapter 4.
Okay, so that.
So I'd have
this
to
is
look.
just- Okay, so we're hold off, but we don't have a site for that.
Definitely.
But, so maybe you can follow up if you want to email me or something. I'll get something from Tom and try to figure it out. Okay? Okay, with that said, if there's nothing further on 107, we'll move to 108, which is the inquiries to the corporate council. Are there any questions about that? I think, Kevin, I know you had your comments here.
Oh, Chair, thank you for the preemptive calling upon. I think the earlier question was about if there's a way to improve this section regarding the mysterious $200 ticket offer for neighborhood board number 9. Just to see if anything could be changed here that would have addressed that and all the requests that came to try to get information from Corp Council. But I don't have anything further right now.
Well, I would think that Lloyd probably wants to talk about this, but I guess my response would be that, the NCO will do what they feel like they need to do in the circumstances appropriate. Go ahead.
Yeah, you said it well.
Yeah, okay. And I think, you don't want to lock them in saying you must consult with council if certain circumstances appear. So I know, I don't think the board was, the Waikiki board, I believe, was very happy maybe with the lack of clarity, but that was just kind of the circumstances that presented itself. And sometimes you don't get clarity in this world.
Yeah, it's true.
So with that said, are there any other comments or suggestions for that section? Okay, that's 108.
I had a question for Lloyd. You used to always have corporate counsel in this or commission meetings. How did that go?
Because they shouldn't be here. And the reason they shouldn't be, yeah, they
They
shouldn't.
always sit next to the chair.
Well, yeah. Well,
kept
just
it
because it was done in the past doesn't mean, I think it's appropriate. And the reason it's not, in my view, appropriate, and also in theirs, is while they were here before, it is not fair to Corp Council to have everybody firing questions one after the other and asking them to make a decision right now. If we look at the plan and the plan says any questions to Corp Council runs through a written request from me, from the executive secretary, whoever's in this position, then they shouldn't be here answering questions from everybody. And that's just an inappropriate use of the corporate council.
I think that they were here to help move the process along.
I don't
And the
disagree.
chair is the one that asked the questions and wasn't just.
Again, but
around here.
you're violating the neighborhood plan because the plan said any questions the corp council runs in written form through the executive secretary. But now you're bringing the corp council here and everybody gets to ask them a question, which is not what the plan says. The plan is very specific. It says any questions to corp council must run through the executive secretary in a written form.
Yeah, but you can be sitting next to the corporate council meeting, Jim.
You want me to type it up right then and there?
No?
The problem is I'm not going to ask the question.
talking
You
about-
guys are going
talking
to
about
ask the
process.
question.
It's just a question on process, man.
The process says that, the plan says that the corp council, any questions to corp council runs in a written form through the executive secretary. So while, yeah, they're sitting right here, but you're asking the question, not me. Right? So if you want a question to corp council, then ask me. And, if it's appropriate, then certainly. But at this point, I think that's the wrong thing. They will be subject to questions from everybody, and I don't think that's appropriate for an attorney to be on that spot to give you a legal opinion right now. I mean,
Practically speaking. It's something that, really takes some time to take a look at. They can't respond to every
Yeah,
question.
that's-
Please, sometimes they say that too.
yeah, and I think this, the challenge,
It's
a
a
lot of,
double-edged.
the challenge at times is that there is a question, but not all of the information is available. And sometimes the information affects the response to that question, so. It's just not appropriate to have them here.
I would be surprised that they would want to have someone here.
They never did want
They-
Yeah, I mean, I would not.
I sat on the commission when we used to have court in our meetings, and it can derail a meeting. It can derail.
Yeah.
Remember, Tom, it can totally derail a meeting, where people start directing questions to core, not to the chair and not to the executive director. Tom and I remember back in the day, so I can understand them not wanting to be there.
There may be some boards, not necessarily this commission, but other boards that they are, present in the meetings, other commissions and boards, they may have a role actually.
Well, we do,
This
we
one-
have core at our BWS meetings every month, but it's a different construct.
Yeah. But
Yeah.
we had, corporate counsel here the last time we went to the neighborhood plan, and we just got our answers. Moved forward.
Yeah,
A couple of decisions really became really good, but it depends.
I mean, I would think they'd be kind of hesitant to sit here and make proclamations.
Right.
You know, because I mean, a lot of times you want to think about it,
Yeah.
gather facts. So,
But don't be involved in it.
yeah, so I mean, it's all going to go through there. But is there any appetite, you know, not here for me, but from the rest of the committee to make any changes to section 108? 108. Well, we saw 108 for
Oh,
the inquiries. Yeah, we're still talking about inquiries of corporate counsel. Okay, so we'll move on to 109. Kevin Lai asked if I imagine that question is a ledger of those requested expenses available to the public? So am I correct, Kevin?
Yes, Chair.
Thank you. So I guess I'll ask you.
Yes, it is, but there's nothing on the ledger. Yeah, it says reimbursement to authorized expenses, but we have not had to process any authorized expenses. Sorry, you guys working for free.
I would say if there was any issue that maybe we would have with this section is that when you talk about, like Lloyd said, we've never received even any kind of reimbursement request in the first place, but when you have this language, it then presumes that there is a process for reimbursing expenses and maybe a special form that you need to do the request on. We don't have any of that.
We're talking about
Says
board
stuff
members.
But that,
Well, but I mean, like, we don't even have a form that says this is the official reimbursement request form.
But the boards do that. That's the reason.
I mean, would it be possible or appropriate to say instead of shall, may? And that way you put the onus on the member to sort of get pre-approved. I mean, we think, you know, if we change it from shall to may. Look at you, Tom, sorry.
So basically, I have to check the 4105 site.
Okay.
Because some of these things relate to commissions in general.
Right.
And Dylan is absolutely correct, even by my own experience. We always out of pocket pay for our gas, this, that, and the other thing. But the commissioners are entitled to reimbursement for parking or that kind of stuff.
Right.
Well, and I mean, essentially, yeah, it has to be authorized. So that sort of suggests that they never authorized, so it's never an issue. So that's really, it doesn't need to.
But to Kevin's point about, are they available if there were any expenses, that's a 92F request. You just file a 92F.
Okay, so did you get that, Kevin?
Right.
Yes, Chair. I think but my question was, if that information does exist, is that a chargeable fee to find that information if it's not already posted in a specific place online on the NCO website?
That would be up to you guys.
And this is where it goes back to the language in that other section where Kevin, if it was a document that we wanted, we would just email it to you.
Okay, as long as you promise you don't charge me for it, that's all I'm looking for.
It'd probably be in the neighborhood like at most 10 cents a page or something.
Well,
It doesn't sound like it'd be
never
numerous
charged-
pages.
We have never charged anyone.
We hardly ever charge either.
Well, but not to derail this, but it does go back to that section about the price of something fixed by law.
Yeah.
It's like.
Yeah.
We just printed out some agendas and put them on there, but telling anyone who walks in the door, hey, give us 15 cents for that.
So I guess at the end of the day, it's possible, but the current policy is not to charge. And plus, they don't have any, so there you go.
The research and the documents were originated with DEGS to state.
Yeah, it would be more of a process for us to charge and put that on the ledger, and everything else, and then be just something else.
It's actually more humbug to try and charge unless you get people who are do spurious requests all the time. But Kevin, we never charge at BWS, so chances are we probably wouldn't charge either. Doesn't make sense. After a one-page document, probably fluffy.
Okay, so any more questions or concerns about section 109?
Nope, no.
If not, we'll go to section 110. And I just thought we'd scratch out the language about the references because that we can go to court counsel and then we can say to be determined on the effective date. Tom, did you want to offer?
Yeah.
Something. Well, because it's kind of unknown at this point, and we can get the language at a later date.
Tom Heinrich again. This is one of those things that's pain in the butt, but needs to be there. If you take a look at the end of the city charter, Article 16, I think it is, you have your little checklist as to, wait a minute, making a change. When is it effective? When are you done with that transition? So every once in a while, those things become completely irrelevant, but it's part of the history of that document and does come back every once in a while, especially if you're talking about land transactions or whatever, to be, oh, that department was responsible at that moment, and we still have it noted in the chart as an example. So in this case, I've got to go back and take a look at what we originally adopted back in 2008 in this sense. The first part of subsection A is correct in terms, I remember working with this for so long. The rules of the neighborhood commission adopted, amended, whatever, that's one set of rules. That was a separate document. Okay, that is superseded. We're done with this is what we're saying. And the next site as here right now is totally incorrect. As a transition statement, it needs to revert back to what was there originally for the 2008 plan because we were rescinding the very different neighborhood plan at that time. The subsequent versions or additions, until you change the 2008 plan,
Okay.
the rest of those are just covered by as amended.
Okay, so can I break it? This is a very technical thing. I don't think this is a decision we need to make as a committee because it's you got to do the right thing, right? So why don't we?
But it can go at the end in one sense.
Okay.
It's like some of your earlier conversation on some points as to how do you track certain things or whatever. Well, for a lot of things, you set it aside separately as tables of disposition. You want to find where it goes, go look at the notes over there.
Well, then why don't I suggest that we put off this particular provision and then when we finish with the whole proposal, we can address it at.
Because this would fit in literally at the end.
Okay.
Okay, where are we now? We're
Yeah.
done with that, we're done with that. This is the one that applies.
So is I'm sorry, I didn't mean to cut you off, but.
No,
We don't want to spin our wheels.
Because what you're doing now is you're simply amending the 2008. So this site here needs to be corrected to back to what it was.
So with no exception, we will table this until the end.
I just had one thing, maybe for Tom, because there's a lot of like technical stuff there that I didn't really understand, but if I'm mistaken on this, but as it currently stands, this says neighborhood plan 2008, 2015 version. Well, we're currently on the 2019, but there was a 2017 version as well.
Yeah.
So is this in itself incorrect right now, even if it is?
Yeah, we can deal with those arrows.
Okay.
Okay, so Kevin, did you want to add something?
Chair, thank you. I think I understood Mr. Heinrich's comments. The sidebar question I posed in my testimony, I think was pointing towards that this was going to be a wholesale replacement of the neighborhood plan, how that language in subsection A would need to change. And if we need to delay that, fine. For subsection B, the question I posed, I believe, was what of outstanding questions that had been submitted but not yet acknowledged by the commission? Would those get rolled into the quote unquote new rules or still retained under the preceding rules as is in the current subsection or subpart B?
The way that I read B is it would be under the current, under when it was submitted. So under the plan at that time. So to roll back to the first question about whether this is an amendment or replacement, I think that remains to be seen. It just depends on, I think ultimately what corporate counsel deems it to be. So we don't really have an answer to that. Would you say? And Tom's shaking his head, yes. So, okay. All right. So we are finally done with that one section. We can move on to our section 3 dash, okay, so we'll go to 201. Yeah, so chapter 2. Actually, we're probably going to need to go back there and reword those a little bit. I'm sorry, when I first did the reorganization, I think I messed some up. So we won't worry about the subchapter names. We probably need to, but let's just go by the numbers. So it's 201. General powers, duties, and functions of the commission. So Kevin, I noticed you raised a question about who's in charge of oversight that ensures that the NCO is acting properly. Can you expound on that? Do you recall?
Yes, sir. If I can recall, Chair, I think it was when there were frustrations that arose when it appeared that neighborhood commission office personnel might not have been following what were felt to be the rules prescribed within the neighborhood plan. What's the process for appealing that? And I think in speaking with managing director, it ultimately came down to you have to sue the city. So that, of course, is frustrating. I think that comment and question was written there to try to find if there's any way to clarify that or provide a pathway for a non-civil suit request if all the directions were underway. Again, especially because prior attempts to submit questions for clarification and interpretation as per the current neighborhood plan had felt to be been non-fruitful. But I apologize for the lengthy response and that the sidebar question was not very focused.
That's okay. I think as I recall, in Hawaii revised statute 92 or maybe 91, I can't remember now, but there is a process and one was unfortunately civil action against whatever governing authority, the city in this case, would be necessary. I suppose you could appeal to the mayor or something, but Lloyd, I don't know if you want to comment.
No, because it's a charter, it's in the city charter.
The structure of this is it's in the charter, so.
Yeah, I mean, so there's not really much that the commission could do about it. I think,
The
so,
practical point here is that that doesn't prevent people from complaining to the commission if they have a problem with, office or something. And usually those things are, easily resolvable, it works out. And, or something is explained to, in terms of what their decision or what they did. So usually, I don't think this is a problem because it shouldn't, and I don't think it does practically prevent anybody from complaining what happened, something.
and bottom line, I don't think we're going to get the authority to go firing the executive secretary or having domain over the executive secretary anyway. So it's kind of a good point.
And its oversight should be by the managing director anyway.
Right, and that's what it is. Yeah, so we're kind of stuck.
It's clear because the commission provides policy and oversight. But we don't control the administrative office and day-to-day operations. That's the,
So Tom, did you want to add something real quick, please?
Yeah, thank you. just in response to the little conversation we were just having, it's not on the agenda, but subchapter 4, sections 401, 402, exactly deals with the review of actions and activities. So I think the question is resolved there. It does not address potential lawsuits. We know you can always file a lawsuit if you wish to challenge. But by any person may seek the review of the commission's actions and activities. So that's coming up later in subchapter 4.
Okay,
For this one, 201, I just want to emphasize, it's brief because the charter directions are brief. What was added for the 2008 plan was because of continuing questions and frictions, if you will, at the time, was making it clear here in the rules for the commission that the commission shall not be responsible for nor control the administrative affairs or day-to-day operations of the commission office. Okay, there's some oral history on that, but you've got your one sentence that addresses it. You got a problem with that? Go talk to the mayor or managing director. Right? This is where it goes.
so I'm hearing, there's no, desire to make any changes. Okay, so moving on to 202, political activity. Have a chance to that or review it, number of us.
Looks good to me.
Did you have any thoughts?
Something?
Not there, but, I think the only one on 202 that we thought was a little strange, not necessarily, not really an opinion, but we just did think was strange was, the B, which was the commission may conduct candidate forums. We don't know if anyone's ever done that, any commission.
Not the commission.
Wasn't
Boards-
there
Wasn't it-
NCO?
They took out the board.
Yeah, boards then.
But wasn't there a desire at one point, a discussion about
Yeah.
NCO, which I assume, I mean, it'd be under this title.
Yeah, it
So,
was an interesting discussion.
well, might I suggest, we could leave it in, it doesn't mean you have to do it. Because the problem is you take it out, then you'd probably be prohibited from doing it.
Right.
And so unless you want to say everybody be prohibited just by, because it's not a bad idea to do it,
It's not a bad thing.
No.
yeah, so I mean, to me, leaving it in, you just say we don't do it. It's just your decision not to do it.
Puts out, I think we could have a mayor,
That's what I was
they
thinking.
all
we're doing, yeah.
candidates that say we want to, one candidate says, I want to get rid of all the boards. And then others say, no, so you want to have it. Well, just discuss that. I mean, that's happened. In terms of that.
Okay, so Kevin, do you want to offer something?
Talk about that later.
Thank you, Chair. Just to note that Neighborhood Board 13 did sponsor a candidate forum during the 2022 election cycle. So I wonder if this is language that will be duplicated or elsewhere if there are neighborhood
Yes.
board specific language.
Yeah, there is an identical provision. I don't know if it's completely identical, but in the board related section. So we're going to cover that at a later time. Thank you.
Yes, worked when we did it a few months ago.
Okay, so
I know, so good.
Yeah, I know, but this is a commission.
It's for commission.
The commission provides oversight.
those.
Oh, for those forums?
Policy, yeah, oversight, so.
Well, you mean outside for the boards, we haven't got to. I'm sorry.
No, I'm talking about providing oversight in the candidate forums. To do a
Oh,
candidate forum, a neighborhood board's got a submitted agenda and coordinating with,
Well, that would probably still be in the board section. No.
you don't think the commission has anything to do with it?
Well, I didn't mean that.
No,
There should be somebody to provide oversight. If they just can't, just carte blanche, just, candidate forum.
What are your thoughts?
well, actually, we did have something, I didn't have something about candidate forums and actually running for office, but I think it'll come under the board section
oh,
as opposed to this.
Well, but I think
this,
applies to, this apply here too, if the sections are separate.
I guess, yeah, and I guess, and two things right now. One is, one of the things we discussed is, there is in the plan where if you can run for office, but once you're elected, you need to resign from the board.
Right.
And I think our discussion was centered around, once you file for an office, you need to resign. And it's because you don't want the boards to be used as a platform for that person. And which also could apply to the commissioner too. That if any commissioner decides to run for office, they should just resign from the commission.
Well, it does say that the commissioner shall not use, official title or membership position to engage in political activity, which obviously the running would be.
Well, that just means that you can't say, hey, I'm a commissioner and.
And I can't be.
Well, I know.
But I think, so really it stemmed from the boards themselves, our discussion stemming from the boards themselves. But if we were to keep these sections separate, this one, because there's almost a duplicate of this, but for the boards. So if we were to keep these sections separate, then you think we could modify the board section that, because right now the board section says, if you run for office and you get elected, you should step down, but it doesn't even say that over here if you're a commissioner. So that's already lacking over here anyway. But in terms of the parameters, and this is just, we don't have the language in front of us, but this is just an idea we had, was just, if we're going to modify the board, so we make a modification over here too, that would basically be whatever the appropriate language is, because people use different terms, file, pull papers. We would find the official language, but basically, as soon as you do that process, you are officially a candidate running for office.
Yeah, I say file.
That would be the time of resignation from the board. And the reason that discussion was prompted was really just because we've had a ton of issues, especially recently, of board members running for office while still being on the board. And it's really difficult to separate out ourselves if there's an advantage to being on the board while running for office, if there are ethical considerations, if it's a platform for that person, and it just makes it so difficult to separate out, that person's running for office while being on the board. So,
I have plenty to say on that when we get there, but what I would recommend is that this section should mirror whatever we do on the board section.
yeah. So it's not necessarily saying, that's exactly the language, but to what we were saying, it's, like whatever, if they're going to be separate sections, they should mirror each other regardless.
Yeah.
Well, I hate to keep pushing things on, but what we can do is, so when we get to this section in the board, we can refer it back to 202 and make the appropriate changes to 202.
Yeah, I don't feel that we're putting it on. I think it's just when we get there, we just mirror whatever.
And this will give us a little time to kind of think about it too.
Yeah, and I do agree that because you can make the argument that the person has a right to run, anybody has, everyone has, and that shouldn't remove you from other things you do, but at the same time, like Dylan said, the challenge is always going to be a person running and not utilizing their position to further, all of a sudden their cost changes. And not all of a sudden, but there are times the cost changes and it's the promotion of their race as opposed to being a.
And the negative that happens out of that is the neighborhood board suffers.
And the community.
That was your shaker and mover
Right.
and the leader of the board.
So we had a neighborhood board meeting that just happened maybe a week or so ago, and a person on the board is running for office, and there are people outside the meeting holding an anti-this person campaign sign.
Oh, that's sad.
Yeah, but that's the type of issue we run into. Then people turn to us and go, "What do we do about this? Is this
Yeah.
a violation?" And it makes the meeting worse because of this.
Right.
And that's a shame, because I've never had that problem in our board, but I can see where that would happen in other areas. It's a shame. Because for me, my person, like Larry just said, I would hate to, we have enough trouble filling seats at times, but we hate to have somebody step down because they want to run for office. You need to, if that person wins, you should be working to try and fill it, but if they don't, and you're lost, and you stop, you know what I mean? It's just, you gotta go through the whole Mickey Mouse of
You have to be
replacing them. Yeah, so, but that's for another discussion. Sorry.
Yeah, there was a question on that even with NCO persons being on the boards to make sure that they have the, there's no duplicity there in their commitment, one way or the other.
Tom, would you like to add something?
Yeah, thanks. Yeah, there's a lot to throw. This is a whole different conversation. But specifically for, whatever section you're on, political activity, and stuff, I just want to emphasize two things. Three things. One, it's almost a matter of training and, getting folks very much aware of what some of the issues are, that kind of stuff. A lot of issues are dealt with by disclosure, which a lot of folks don't disclose that are a candidate. That's true. Having said that, the other thing here especially is I would strongly recommend that it remains clear that the commission and the boards may conduct candidate forums because there's different audiences, there's different situations, especially when you consider, if you will, some certain other circumstances I won't get into now that also involve the charter commission. In that regard, the distinction between the commission and the boards, but having the authority under the rules to conduct candidate forums, I think is very important. And then the last thing is just a note, regardless of what the proposal may be or whatever, of, I will say, disqualification from membership on a board, like if you register, wherever you draw the line, the bottom line is you cannot, in my opinion, you cannot make that same statement for the commission because from past dealings with Corporation Counsel, the qualifications to serve as a commission are established in the charter. So if you wanted to add that disqualification, it would probably have to go through a charter amendment. I've discussed with some of you in different conversations, a pet peeve is wearing two hats, a commissioner who serves both as a commissioner and a board member upon appointment. The only way to address that is through a charter amendment. Okay, so it made the cut the last time, but it didn't make the final cut in the charter commission to go to the ballot. But then again, the whole point of that was you gotta direct that one to the charter. So it's a whole different chapter.
And there is a difference between a commissioner and a board member.
Yeah. So it's beyond the scope. Yeah, but there's a whole bunch of other neat things to talk about at some other time.
Okay, thank you. So, we can circle back to this when we address the board related, issue. So moving on, section 203, it's our last section to review in this conference of chairs. There was a question, I don't know if Kevin's still with us, but he just, I think it was related to the, oh, okay. It was related to the two or more people, right? Or more than two attending a conference, right? All right, go ahead, Kevin, if you want to state what you want.
Thank you, Chair. I think that was a point that I wanted to make. I've just posted to the chat the requested change for subsection A of 203, which would, again, I think help clarify for naive readers the differentiation between chairs and of the neighborhood boards, which are, I believe, going to be invited to the conference of chairs. The language might be helpful for those who are new to the boards. And that's the proposal that I had made there. The other items that I'd submitted in earlier testimony were mainly just typographic and grammatical, and we'll be touching on those at the end.
Biannually, twice a year or every 2 years?
2 years.
It says at least, right?
Yeah.
Okay, so that means you can do it more frequently.
You know, we may want to update this because electronically, we can add a lot more people than just 2 people per board.
I think it's a sunshine law issue about having more than two, then you start to get into sunshine law issues. That's why they have it, the chair and the vice chair, correct?
Yes, but that's a legal item from the board side. It's not a utilization of the conference themselves as a training tool for the board members. depends what, where you look at it. OIP looks at it like it's just, it's a requirement actually for the, chair and vice chair be there. It's actually a requirement. But if we take that and extrapolate the conflict of chairs and make it more into a training session, electronically, it could be a great value to the boards.
That's not how I read it, but I'm not
Yeah,
sure,
so
so.
we're not, because it is the
Yeah.
conference of chairs. And
Yeah.
That's right, it's a legal.
That, and training is a different.
Yes,
Yeah, so we get-
yeah.
But I mean, if we just opened it up electronically,
Well, then I would
it's
just,
something 416.
if you want to do that, I would have a separate section that says, whatever you want.
Well, yeah, because I was gonna say that actually, as it stands, once again, not the exact language, but when we read it, it gets to a point where like this section is called conference of chairs, but then it proceeds to give you all these other ways where it's not people who are the chair or vice chair. It's like the chair and vice chair or their designee, or if the chair is a commissioner, then they could have additional designees. At a certain point, it goes, well, then why is it called a conference of chairs?
Yeah.
Right, that's right.
It's because we're restricted by the law. That's the problem. So Larry?
Yeah, one mention here is, I guess I read this, the commission shall at least biannually assemble a conference of the chairs to include a chair and one vice chair and designees. We all know that Lloyd runs this thing, and it all starts with him. He picks a date, when he comes to the commission, you guys agree. The way I look at it, the verbiage should read that the commission sponsors the conference of chairs, but the facilitator is the commission office with Lloyd. And your objective is, with the conference of the chairs, to reach out to the leadership of all the boards, because too many cooks in our office are going to screw it up. He wants to talk to them because latest policy changes that come out from the commission and his office. And he wants to get to those chairs, wants to hear them. If you get too many people involved, he's getting bombarded with so many people wanting to talk at one time. This way, the smaller the group, his objective gets completed, the chair is responsible to talk to their, the boards to let them know what was the outcome of that conference with chairs. That's just what I see it.
By the way, biannual means twice a year.
A year.
Yeah.
The way it's spelled.
Yeah.
The worst one is bi-weekly. And that's actually ambiguous.
Well, I think you have two things here. Steve's talking about training, which is a whole different issue. Conference of chairs should be exactly that. It's the vice chair and the chair to deal with issues that the executive secretary wants to. Because it does get messy, the more people you get in the room. I'm with Larry. Gets very messy.
So I mean, what I guess is if you legitimately just have a training, maybe that would not, since it's not policy related, perhaps you'd say it's not covered by sunshine law.
You add a section later.
Hey, the way it's.
I mean, I don't, but,
Section on training.
but, okay. Tom, do you have any insight into this?
Well, I mean, that's a.
So just on the last thing that you just said, I recall, I'm sure Kathy does too, when especially we had some situations with lawsuits against several labor boards. And what was absolutely wanted and finally happened was meeting with Corporation Counsel in order to provide, in essence, some advice to board members. Folks wanted black and white answers, not going to get them.
Yeah.
But the nature of the meetings as scheduled at Blaisdell was in the form of advice and training that was available for all the board members. You guys listen, we're providing this equally to everybody,
Right.
okay? And so it was in that context of what I'll use as training. The council, conference of chairs, and other things that you could do with it is different than that, so that the way we crafted this at the time was to try to urge the commission to make sure that you got together with all the, you make the invitation, they got to show up. But you get together with the board leadership. Okay, let's try to limit that leadership, otherwise it does get to be too much of a cattle call. So having said that, there's a couple of things that I would very strongly suggest with 203, because from everything I went through for 12 years, this one is still probably the one that bothers me the most. And that is to save this in the plan was finally a compromise just to make this at least once biennially, at least once every 2 years, the commission should do X. Because the chair of the commission at that time absolutely didn't want to meet with anybody, period. So moving on, my suggestion, because there's still the flexibility, but the key is if the whole point of all of this is communication, okay, to increase and assure effective citizen participation, blah, 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 then I would suggest, and I'll put this in writing, subsection A should begin with at least once annually, the commission shall, okay, the rest goes on. And I would vocabulary change besides the commissioner, be in addition to the commissioner, because that still deals with situations of concurrent participation. And then lastly, different idea here, but somebody mentioned this a moment ago. For subsection C, I would also be clear, and I'm still in the context of the commission. The commission may assemble the conference at any time or location. Okay, understood, straightforward. I would add to that, and may assemble the conference on an island-wide and regional basis. In other words, the concept that folks have been talking about exclusively has been conference of chairs, get everybody together. And the whole point is you guys can do it any way you want. Changing my comment. There is, from this discussion, also then, what about putting this idea of the boards themselves can convene their own council of chairs or whatever else you want to call it to distinguish, because the boards can get together any way they want, schedule a special meeting or schedule a meeting of the chairs, but notice it, okay, get a public notice out there and whatever. And especially to be encouraged to at least collaborate regionally, whatever, but the boards can do that. Few chairs have been interested in doing that, but they're not quite sure of the mechanics of how to do it, okay? And then later, I'm not going to dig for it right now, but there's very specifically in the next chapters, that whole point about encouraging the boards, the chairs, to work together regionally, to collaborate, to convene special meetings, whatever. So it's not just, I stay away with the boundaries, okay? So a couple ideas there, again, I gotta write it out so you can look at it.
Yeah.
But my biggest pet peeve for years has simply been to just say that at least once every 2 years, then the commission itself, particularly as most of you have been board members, that communication itself right there is missing, and you need to do it more regularly. Zoom has changed that totally, and I don't even address that yet in my thought process. Thank you.
Thank you. Before we go on, Kevin?
Chair, thank you. I, again, had posted to the chat the clarifications that I was hoping could be considered by the board, or rather the commission, rather the committee tonight regarding clarification of board chairs. Mr. Heinrich has submitted and proposed some additional changes. That's one thing to consider. But secondly, do we have absolute clearance from OIP that at the annual, rather the biennial neighbor board inauguration ceremony, that at that moment that everyone is sworn in, is that still a legitimate and okay meeting?
Yes.
I'm hearing someone say yes, but that's Stephen, but I don't know that for a fact.
Well, I say yes too. I don't know why it wouldn't be. It's just,
Present. Yeah, or you, I have people, you have a problem.
I mean,
Yeah.
we've done training at
Yeah.
those meetings in the past,
Yeah.
not recently, but in the past
In the
we
past,
have.
with that,
The-
commission.
Only issue I have with doing a board-wide training is you start getting into some particulars, and I think that's when sunshine would get invoked and get in trouble.
Problem with that is the timing, that's why I think, like, for example, this last one, it's much shorter, it's just basically the slate of meeting.
Keep it simple. I know they've got
The rest
very
of the
basic,
training,
yeah, just the
It's just the
swearing.
timing.
Yeah, the
We
timing, yeah.
go all day almost, training.
Well, there were some things that you folks reviewed in a PowerPoint to the new inductees. at last year's 2023 installation, right? It was brief, PowerPoint, new inductees got the message, and then done.
Okay, Kevin, did you have any more, or, because your hand's up, I see. Did you have anything else?
Just to clarify that, I only raised that question because I remember Executive Secretary perhaps jokingly saying at one of the inauguration ceremonies at the Philcom that technically it was an illegal meeting. I just want to make sure that had been addressed since then. Thank you.
Last year.
Yeah, we're never gonna have that again.
So,
But it is a good question. I will follow up here.
okay, so let me ask you just the one thing that, does anybody want to change it to once annually? And do we want to mandate that? Because that's gonna be a mandate.
Clarify that. I think we should leave it as it is.
Just leave it as.
Is
I
it-
like-
Yeah, okay, because you would go at least.
Yeah.
Did you want to, in light of these new suggestions, did you want to table this for the consideration, or did you want to
Table.
leave it? The consideration of section 203, or did you want to leave it as it is, asking the committee?
I don't have any other, I think it's fine the
It's
way
fine.
it is.
Okay,
Or I think
I
maybe
agree.
we might have more input later.
Okay, so-
Maybe we should add a section for the board about training,
okay.
but this is okay.
Okay, so we've accomplished that part of our agenda, and
Okay.
we're really at the end. So I will just have the announcements. We are slated to meet November 18th. I haven't looked at that calendar, see if we get too close to any other special days. But I mean, I guess we can tentatively say it, but
Yeah, this is.
for right now, it'll be November 18th. I will say, and we can't discuss it because we can put it on the agenda, but I asked Richard if we could put on the agenda, maybe proposing a resolution for the commission to ask the legislature to exempt the neighborhood boards from the sunshine law. And so I just throw that out there. And we're not really supposed to talk about it.
Yeah. we're gonna have to-
But I can announce it. It's just an announcement.
That's right.
And that's next week.
Thanksgiving.
That's a waste of time.
That's it.
That's a way to get.
Yeah. So that way, stay tuned. Are there any last comments or questions from the board? Any announcements? Hearing none, I was in the meeting. Thank you, everybody.
Thank you, great job. Yay.
Thank you, Kevin, for all your great input.